Frequently asked questions, I'm going to do it again. Frequently asked questions, related party issues, and looking at some specific private letter rulings and a recent tax court decision. On a previous segment, we talked about the related party rules and some of the restrictions. In this short segment, we're going to look at several or a couple of private letter rulings. These are rulings for taxpayers and their unique situation that provide a little bit of guidance. In Private Letter Ruling 2012-16007, this is a situation where an exchange was done with related parties and a boot of up to 5% was permitted. In Private Letter Ruling 2012-120012, this is one where a taxpayer did an exchange with a related party, who did an exchange with a related party, who ultimately bought a property from an unrelated party. So this is one where you did the exchange happened with related party to related party to related party, and then finally, ultimately acquired a replacement property from an unrelated party. This might provide some planning opportunities, or at least some creative ways to approach things for taxpayers that own lots of investment real estate, maybe opening up the door to do potential related party exchanges with other entities that they're related to. The other aspect we want to look at was a tax court decision, the Mullalani Group tax court decision in 2016. What happened here is the taxpayer, goes by MBL, was a subsidiary of Mullalani Group, who happened to be a related corporation. Well, what happened in this one is the taxpayer intended to identify and purchase property from unrelated parties. What they ultimately did, though, is they identified on day 45 a property that was owned by Mullalani Group, which is a related party, and that group used NOLs, or net operating losses, to offset a portion of their gain. And the taxpayer argued that they didn't have any plan to buy this property from a related party. They really sought to purchase from an unrelated party. They made offers, they looked at properties. It was only at the very last minute that they identified this property that was owned by a related party. So at the end of the day, the tax court did find that this taxpayer had tax avoidance, which was in violation of Section 1031F. And what the tax court looked at is they really didn't look at the taxpayer, MBL, and the other entity, related entity, Mullalani Group, as separate entities. What they looked at them was kind of a single economic entity. They looked at them in the aggregate. And what they determined was, in this particular case, because Mullalani Group was able to use net operating losses to offset their gain, exchanging with a related party, they were in a better tax position than if MBL went ahead and bought a property from an unrelated party. So they ended up in a more advantageous position. Therefore, their 1031 exchange was denied. So one thing I want to stress, in any related party exchange, it's important that each taxpayer review their individual facts and circumstances with their tax and legal advisors. To review your specific 1031 exchange situation, contact Asset Preservation's headquarters in California at 800-282-1031 or our Eastern Regional Office in New York at 866-394-1031. Please read the full disclaimer, as Asset Preservation cannot provide tax or legal advice.